Sometimes title closers have questions about the 1031 documents and what their responsibilities are to get the closing done correctly so they don't mess up the 1031. One of the most important things that the Treasury regulations requires is that the exchanger, the party doing the exchange, must assign their rights in the purchase agreement to their qualified intermediary. Well, that's great, but under the Old English common law, an assignment was not considered effective until all of the other parties to the purchase agreement had been given written notice. And the IRS adopted the same requirement in the Treasury regulations. So at the time of closing, that notice of assignment, that the exchanger has assigned their rights in the purchase agreement to the intermediary, that notice must be given to the other parties. So for the relinquished property, the notice would go to the buyer, as well as any assignees of the buyer. So the original buyer and any assignees. Further, if there are co-sellers, other parties conveying the relinquished property that are parties to that purchase agreement, they too should be given written notice. Now, how do we prove that we gave all these people written notice? We ask them to sign an acknowledgement stating, I have received this notice in writing. And so that's part of the closing documents that the qualified intermediary sends to the seller to make sure that all of the proper parties are given the requisite notice.